Lawyers, what's a law that isn't real, that normal people insist exist? Story 1. Probate attorney here. I've had many people ask me when the reading the will is going to take place. I explain to them that only happens in movies. But one of these days, I'm going to have to hire a mysterious blonde wearing a veil to sit in the corner quietly. Then I'll tell everyone that she inherits everything. Provided, of course, that she must adopt the descendant's cute but troublemaking 6-year-old child that no one knew about, or she can spend the night in a haunted house. Her choice. Story 2. One of the most frustrating things to me, even though it's not really a specific claim that a particular law exists, more of a rule of evidence, is that's just hearsay. You have no evidence. Comes up all the time, in all kinds of contexts. Even lawyers love using it when it suits them. Nothing but hearsay and speculation. Usually, what people mean to say is, I don't believe them. They're lying. Which is fair enough. But that's not what hearsay means. Lots of evidence is just a person talking. That's what a witness is. It's why testimony exists. It's not evidence just because a person is talking. Hearsay just means that in most cases, you have person A says that person B said XYZ. In order to prove that XYZ actually is true. Hearsay. Get it? A heard B say it. It just means your witness can only talk about things they actually know about. And, extremely importantly, it doesn't count as hearsay when person B is actually the person on the other side of the case. Person A is totally allowed to say, person B told me yes, I will commit the crime on Tuesday. If person B is the defendant, who has been accused of committing the crime on Tuesday, you don't get to complain it's hearsay if you're the one who supposedly said the thing they heard. Story 3. Negligent motorcycle driver forced me to hit him from behind with my car. I was young and naive at the time, having never seen an accident until then. Guy makes me sign a paper that says that the accident is my fault because I was hit from behind and wanted compensation. I explained the situation to my dad, and he concluded that the guy was obstructing normal traffic and I had no option but to hit him from behind in the particular circumstance. The guy ended up taking us to court, and I showed the judge the piece of paper that I signed. I explained that I signed it under duress, and that he explained that, by law, whoever hits from behind is responsible for the accident. The judge looked him in the eye and asked him if that was true. He said yes. Then she asked him to point out which law states that. He just shut the hell up. Screw that guy. Story 4. Good Samaritan laws aren't nearly as broad as people think. For context, I work in emergency services. Some people believe that I was trying to help are the magic words that can get them out of any sticky situation. Good Sam laws vary by country and state, and the medical examples are a little more black and white than others. Adding a non-medical example of what I'm talking about. Imagine you're driving your car and you notice someone on the side of the road who needs help. As you swerve off the road to provide assistance to that person in need, you incidentally run a child over on the sidewalk. After the situation is over, you're definitely not free from the consequences of running over the child with your car just because you had good intentions of helping someone else. Versions of that story have occurred, and the drivers have tried to use a Good Samaritan defense because they meant well. There is absolutely some gray area on the subject, but if your unprompted action undoubtedly makes the situation worse than if you've done nothing. Having good intentions is not a get-out-of-jail-free card, and a bunch of people don't understand that concept. Story 5. I'm not sure if this would technically be a law or not, but the way tax brackets work. I've repeatedly heard people in retail or construction say something to the effect of, I'm going to turn down this shift because if I take it, I'll go up in the next tax bracket, and so will pay more in extra taxes than I will from taking the shift. The tax system is specifically designed not to do this. Here's an example of how tax brackets actually work. Say there's a tax bracket at $10,000. The rate below $10,000 is 5%, and the rate above $10,000 is 10%. People seem to think that if they earn $9,999, they will only pay 5% of that, $499.95, in taxes. But if they earn $10,001, they will pay 10% of that, $1,000.10 in taxes. How it actually works is you pay 5% on the first $10,000 and 10% only on the dollars above $10,000. If you earn $9,999, you pay $499.95. But if you earn $10,001, you will pay $500.10. You earned an additional $2 and paid an additional 15 cents in taxes. 5 cents on the $10,000 and 10 cents on the $10,001 dollar. Of course, there's all sorts of weird interactions between taxes and government programs, especially when someone is receiving certain government benefits. It is totally possible for each dollar you earn to be taxed back 1 for 1, or worse. In that case, there is a genuine disincentive to work more hours. But for a normal worker thinking about how many hours they can work before they end up in a higher tax bracket, you will never earn less by working more. So just work as much as you like. Story 6. It's a federal law in the U.S. that plainclothes officers or undercover police officers have to identify themselves as law enforcement if asked. No, it's not the law, and they can tell you whatever the they want. There's no federal law requiring uniform officers to identify themselves or provide their badge numbers. Most police departments have policy directing them to do so, but it isn't a legal requirement, and there's no punishment for failing to do so. Police don't have to tell you why you're being detained. If they do, or if they vaguely address your questions, it's only to get you to keep talking to them. Police can tell you you're not being detained, then suddenly decide you're being detained without telling you. That's right. You never 100% know you're suddenly being detained. And under Supreme Court case law, you're supposed to figure all that out yourself based on how the officer behaves, giving orders, closing the distance between you, calling additional units, etc. You can demand a lawyer if you're being detained. However, Supreme Court case law has also said that police do not need to provide you with one unless you're in custody. Custody means being handcuffed or placed in their vehicle, moved to another location, strong police presence, several officers possibly with weapons unholstered. Whether you're in custody or not, it's always a good idea to refuse to answer any questions, stating you do not wish to be held or transported for any period of time, for any reason, and requesting a lawyer. Story 7. I'm not a lawyer, but unfair firings are oftentimes not illegal. People often assume that if they were treated unfairly at work, like getting fired for something trivial that someone else got away with, that there's some kind of law that's been broken and they have a strong case for suing. In most cases, this is not true. There are only a few reasons for firing that get a company in trouble. Firing for race, color, national origin, religion, sex, age, disability is illegal in all states. In many states, this means that you can be fired for a medical condition, your sexual orientation, tattoos, that stupid look on your face, your weight, etc. Or just because I'm not attracted to you. Story 8. The legal limit for blood alcohol concentration, BAC, in drunk driving? There's no such thing. The common refrain you hear, especially from media outlets that have no idea what the hell they're talking about, is that there's a legal limit to the amount of alcohol you can safely have in your system and legally drive a car. No, simply no. It doesn't exist. There is a statutorily established per se limit in every state. This means that if you're driving and your BAC is over that limit, you are per se intoxicated, and the state doesn't require any more evidence to convict you. But if you're under that limit, you can still be convicted of drunk driving or driving while intoxicated. The state will have to provide additional evidence to do so. So, even if you've just had one or your BAC is under the legal limit, you could still get arrested and convicted of drunk driving, DWI, DUI, OUI, or whatever else your state calls it. Story 9. It's a law that exists, but widely misunderstood, is the concept of entrapment. If the police put a bait vehicle in a high crime area, that is not entrapment. If the police are watching a bar known to overserve to see if there are impaired drivers at the end of the night, that is not entrapment. Entrapment only occurs when a government agent suggests committing a crime that you were not otherwise going to commit. This actually happened to an old high school teacher of mine. He thought he was going on a date with a lady he met online. When they met up for the date, who happened to be an undercover officer, she was like, "I'm not really interested in a date, but for X amount of dollars, I'll do such and such." To which he obliged. He was charged with soliciting to a prostitute, but the charges were dropped since he was only actually interested in the date and had no desire to solicit anything until the officer brought it up. Story 10. An arrest isn't magically invalidated if the police didn't read you your rights on the spot. There could be a whole thread of just misconceptions people have from watching cop TV. My little brother seems to be under the impression that at 17 and a half, if he got caught selling weed, which is illegal in my state unless you have a license to sell and a med card to buy when he turns 18, his record would be expunged. He also thinks that driving a motorcycle without a helmet or a license of any kind, not even his car permit, is okay if he does get pulled over. He can just run away from the cops. Also, that his blowing into his friend's breathalyzer thing tied to his car ignition so that person can drive drunk is perfectly fine because he's a better driver when he's drunk. Also, for everyone saying no helmet is not illegal, just shut the hell up. My little brother is a pot smoker, obviously, and was scouted for a D2 school for football. They were really interested in him until his dumb self failed the drug test he knew about months in advance and got kicked off the football varsity team. My little brother once kicked a door and cried for 2 hours at age 17 to go to the hospital because he really hurt so bad. And it was worse than when he broke his clavicle and he was sure he broke his foot. But he didn't break, fracture, or bruise anything. He's just a big whiny cunt. My little brother has a video of himself directing a paintball gun at a cop discreetly from about 2 blocks away with his little friends giggling in the background. Then the cop gets into his cruiser. My little brother and his friends all freak the hell out and run, screaming like wild animals. Story 11. In my country, some people believe they can press charges against someone. You can't. You report a crime, and the police decide if they're going to take it further. It's not up to you whether charges are brought. You may want charges brought, but the police drop the case. Alternatively, you can refuse to press charges, and the police can bring a case anyway. It's harder without the victim or witness cooperation, but they still can. You do have a right to civil cases, of course, but when people say press charges, they believe they can do this via the police. U.S. prosecutor here. In my state, there's actually a mechanism to file a private criminal complaint. Very few people have heard of it, but those that have are often mentally ill or conspiracy theorists. Our process is the person files the private criminal complaint with the prosecutor's office. The prosecutor can then either adopt the case and file formal criminal charges or go in front of the judge with the person and convince the judge that the charges should not proceed. Technically, the judge could force the prosecutor to proceed, but I've never seen it happen. I've also seen one private criminal complaint get adopted formally. When a private complaint is dismissed by the judge, the person usually files 5 more complaints against the prosecutor, the head prosecutor, the judge, the presiding judge, sometimes the governor, president, etc. Then a substitute prosecutor has to come in to dismiss the complaints, which causes a whole new round of private complaints to be filed. They're almost always a waste of time, but many times they're at least entertaining. Story 12. In the UK, people often claim if an item is listed for sale in a shop, then the shop has to legally sell it to them at that price. This is not true, as the shop doesn't have to sell you anything at any price. Often as a gesture of goodwill, shops will honor erroneous prices, but they are under absolutely no obligation to do so. Back when I had a goldfish, rest in peace, Carl, I went to Pets at Home to buy him a bigger tank. It rang through at £0. The checkout girl raises an eyebrow. We both share a laugh. She messes about with the system a bit more, but all she gets is £0. So she calls a supervisor. We wait a few minutes, a few more. The queue is building up behind me. Eventually, she shrugs, prints a receipt for £0, And she sends me on my way with a free fish tank. Good day for me and Carl. Story 13. If you live together for X period of time, you're automatically legally married. There are different time periods for different purposes, and being common law doesn't always have the same effect as being married. So, for example, your employer might give your partner spousal benefits after 1 year, but division of property laws might only apply after 3. All of this varies from one place to another. Some places don't have division of property laws for common law spouses, for example. Story 14. Not a lawyer, but here's what bounces around legal advice every couple of months. The age of majority in Mississippi is 21. So people say your parents control your life until then, and you can't move out without permission until you're 21. The truth is, the law means that they have an obligation to provide for you until you're 21. You can move out at 18 and not face any penalty or be forced to return. Although the age for Mississippi emancipation is officially 21, this only refers to emancipation from a parent's obligation to support their young adult financially. In Mississippi, individuals aged 18 and older may vote, enter into legal contracts, take legal actions against others, and be sued for damages. Similarly, an individual aged 18 or older who moves out of his parents' home is not considered a runaway in Mississippi and is not legally required to return to the family home. Story 15. Circumstantial evidence. Often, pop culture's portrayal of criminal law tries to draw a distinction between hard evidence, like blood at a scene, or a weapon in the suspect's possession, from circumstantial evidence, such as what a witness heard or mismatched entries in a calendar that contradict an alibi. How often have you heard a TV suspect, when confronted with some facts, say, "That's all circumstantial. It's not enough to convict me"? The viewer is left with the impression that the facts presented don't matter, and the law weighs circumstantial evidence less. In reality, the law doesn't afford any more weight to one type of evidence or another. There isn't even a formal distinction in criminal rules between the two. There is an academic distinction. Hard evidence, also called direct, is based on direct observation and doesn't require any explanation beyond the facts themselves. Circumstantial evidence requires some interference to arrive at the important fact to be proved. For example, a witness testifying he saw the suspect stab the victim is direct evidence of the action of stabbing. But that witness could then testify before the stabbing he heard the suspect demand that the victim hand over his wallet, and the victim refused. This is circumstantial evidence of motive. You can infer that the suspect then stabbed the victim because he wanted the wallet and didn't get it when asked. Circumstantial evidence is often vital to establish certain criminal elements like motives that can directly be observed. But there is no get-out-of-jail-free card just because the evidence is circumstantial. If your wife hears you're plotting to kill her and she sees your axe sharpening equipment in the attic, your neighbor finds a copy of how to kill your wife and get away with it, and you write an email to your brother saying, "I'm going to do it tonight. That hoe cooked my steak well done," you're probably going to go to jail for murder. It's irrelevant that you destroyed your axe, cleaned the basement perfectly, ensured no witnesses, and fed the body to pigs. Circumstantial evidence can be enough. Story 16. When my parents die, the government is going to seize a big chunk of the inheritance and I'll get nothing. In the U.S., this is a very common misconception. Although state inheritance tax vary, the U.S. federal taxes on inheritance usually don't kick in until the estate value exceeds $5 million. So for the vast majority of the working class folks, the federal inheritance tax won't have any effect. But people will still talk to their family lawyers and ask how much Uncle Sam is going to take away when mom or dad dies. I had a coworker who was a Southern Kentucky farm boy through and through, very rural in accent and mannerisms, but very sharp and hard-working, and genuinely one of the best coworkers I've ever worked with. And he'd often talk about the family farm. He was mad because once his grandfather passed, the government is going to want to take a big piece of the estate and we'll have to sell off the family farm. I told him to look up the estate laws because the minimums on that were in the millions of dollars range. Well, yeah, it's 8,000 acres of farm with dozens of employees. I then learned that this very rural farm boy was one of the heirs of some kind of enormous agricultural operation. Story 17. Former divorce lawyer. Committing adultery doesn't change what somebody is normally entitled to in a divorce settlement. Divorce law is all about what's fair, at least by the numbers. Divide the property equally, pay the correct support according to income, etc. All it does is speed up the time it takes to finalize a divorce. But to do so, you still need an official statement in place. Custody, property division, etc. Which takes time anyway. So it's usually a moot point anyway. So really, cheating isn't all that relevant. I had clients insisting on finding them out, just to prove a point. Wanting court orders to get records of their ex's phone calls, trying to show me records of text conversations. And I just have to be like, you already been separated for a while now. It doesn't matter in the eyes of the law. So let's focus on the settlement now. What are the incomes? What's the property worth? If you can't afford to buy the other one out, you gotta sell it. Sorry. Story 18. Former divorce lawyer here. What always boggled my mind isn't what people thought the laws were, but what they thought was relevant to a divorce case. Example. The client comes to me with a 17-minute recording where the opposing party says he doesn't love the children. The opposing party did not know that they were being recorded, which happens to be illegal in my jurisdiction. It's legal in a lot of places. He once said that he didn't love the children, and the entire 17 minutes is my client baiting him into repeating it. He's trying to shut down, be civil, and not argue, but she keeps badgering. A fight erupts, and they start revisiting old issues about which of the listening audience is clueless. The client says, "Admit it. You never loved them." To which he replies, "I never loved you either." That's illegal. 2, you're doing illegal things to advance this divorce proceeding is evidence of your poor fitness and character to be a parent. 3, you baiting him into saying that makes you look bad. 4, no one wants to hear you bicker and fight for 17 minutes. 5, the judge won't allow the entire thing to be played. 6, you can hear the kids in the background. 7, that definitely speaks to your poor character as a parent. 8, he can dismiss the statement by saying that he didn't mean it. He was just so pissed at you that he said it to hurt you. I've got a better idea how we present this evidence on the stand. Me. Do you have any doubts on why he would be a good parent? Client. Yes. On multiple occasions, he has said he doesn't love them. Me. When was the last time? Client. 3 weeks ago. One of those will hurt your case, and one of them will help your case. Listen to your lawyers, people. Story 19. Cop, not a lawyer. Miranda advisements only are provided when your statement is being taken while in custody. Coercion. A cop doesn't have to read you your rights if he arrests you, but doesn't ask you any questions after the fact. Many friends of friends ask me, "Hey buddy, got popped for driving under the influence, but the cop didn't read him his rights. Does he get off?" The answer is almost always no. Story 20. In California, it's not illegal to discuss your wages with your coworkers, despite what your boss may say. It's actually not illegal anywhere in the United States to discuss your wages or form/join a union, contrary to what many employers may claim. I strongly recommend you do both to protect yourself and your colleagues from being taken advantage of. Story 21. My father, who is a lawyer. Policemen cannot lie to you. This is false. They can and do. I heard you were smuggling animals. What are you, a cop?